come to order. The purpose of today's hearing is to hear witnesses on the subject of the proposed Consumer Financial Protection Agency, implications for the consumers and the FTC. And I certainly want to welcome all the witnesses, Mr. Barr and Chairman Leibowitz. The chair recognizes himself for 5 minutes for the purposes of an opening statement. I would like to thank all my colleagues and all the witnesses who diligently worked to prepare testimony over the 4th of July holiday so that today's hearing would be as meaningful as possible as we commence our examination of the administration's proposal to create a new Consumer Financial Protection Agency. My view on the matter is fairly straightforward. I believe that the FTC should remain intact as it is currently constituted, and that this committee and subcommittee should continue to oversee and authorize the FTC. The commission, which was established in 1914 during our nation's progressive era, was designed to be a regulatory agency with disinterested expertise to ensure competition and to promote free enterprise. That mission and those prescient concerns are as vital today as they were almost a century ago. The Commission operates best as a lone eagle. From high above, the agency can survey the marketplace and swoop down on predators that deceive unsuspecting and misinform consumers. The higher and farther away that the FTC is from other agencies and the entities that it regulates, the better it is at spotting unfair commercial and trading practices and at isolating those practices that cast the longest shadows. Similarly, by staying at a distance, the agencies can keep would-be credit captors at bay while staying on course to achieve its critical mission of protecting consumers. Looking at all reliable indicators, the Commission has performed commendably for small and scrappy staff and abridged powers. Working along with a 5-person bipartisan commission are approximately 1,100 dedicated employees spread out across 3 bureaus: Bureau of Competition, Consumer Protection, and Economics. Although its expertise is deep and broad, the FTC's statutory tools under the FTC Act consist of an antiquated and cumbersome form of rulemaking under the Magnuson-Moss Act paired with anemic litigation authority. These tools may be successful at landing glancing blows, but they fail to pack the full punch of deterrence that businesses will respect and consumers deserve. Currently at FTC's disposal are its expertise and its agency-crafted instruments of research, policy, and study development, consumer complaint and education, competition, legal analysis, and economics. What the FTC does well, it has done without peer relative to its sister agencies. And what it hasn't done particularly well is well in the process of being fixed. Just a few weeks ago, our subcommittee worked intently to mark up H.R. 2309, the Credit and Debt Protection Act, which directs the FTC to adopt rules using APA rulemaking authority that will address rampant, unfair, and deceptive acts and practices in the area of payday lending, automobile finance, mortgage and foreclosure rescue, and debt settlement. Our subcommittee's objective in passing H.R. 2309 was to confer more authority upon the FTC and equip it with sufficient resources so that it could adopt rules faster in the areas of credit and debt through APA rulemaking procedures and bring enforcement actions carrying the threat of civil penalties. Our committee has worked devotedly in the past more than a few times with members from the Financial Services Committee to bolster the FTC's shortcomings, hold out the FTC's best practices for banking agencies to emulate in protecting consumers and to improve the ability of bank regulatory agencies to protect consumers by ensuring unfair and deceptive rules under the FTC Act. I have witnessed the respective chairs of the committees on Energy and Commerce and Financial Services jointly introduce H.R. 3525 to tackle some of these challenges. Further, I offered a friendly amendment to H.R. 3526, which was introduced by the chair of the Financial Services Committee in the 110th Congress, to require that the GAO report investigating federal banking and credit union regulations and the perpetuation of unfair and deceptive acts and practices by depository institutions. Importantly, this push and pull between our respective committees has pressured the providers of financial services and products, including banks and depository institutions, to balance the allure of profits and determination of safety and soundness against the needs of consumers. This collaborative working relationship between committees has produced good and sensible consumer protection bills to safeguard consumers of financial services and consumer credit products. It is a viable example of the independent agencies that will be affected by the administration's proposal, as it will allow each of them to maintain their independence and respective biases, experience, and expertise when addressing serious problems that cut across industry sectors and affect market suppliers and consumers. I want to thank the witnesses for being here today, for taking out time from their busy schedule to be and to participate in this hearing.